Good morning, Your Honor. Case number IT0370I, the prosecutor versus Vladimir Lazarevic.
I thank you and good afternoon to you. Mr. Lazarevic, before we start, I want to make sure, Mr. Lazarevic, before we start, I want to make sure that you are receiving interpretation in your own language. We need to hear the answer, and the microphones are not switched on, so please do help us. Okay, thank you.
I can hear the interpretation.
Appearances for the prosecution.
Thank you, Your Honor. My name is Tom Hannes. I represent the Office of the Prosecutor. I'm assisted today by Pristina Mueller, and our case manager is Susan Grogan.
I thank you and good afternoon to you and your team. Appearances for the defense.
Good afternoon, Your Honor. I'm Mihailo Bakrać, attorney at law firm Belgrade, and I appear for General Lazarević.
I thank you and good afternoon to you too. Before we proceed with the formalities of the initial appearance proper, I would like to give some details relating to this case and more precisely to the indictment. The accused, Colonel General Vladimir Lazarevic, is included in indictment bearing case number IT0370. This particular indictment was confirmed by my colleague Judge Ogon Kwon on the 2nd of October of 2003. And 18 days later, that is on the 20th of October of 2003, that particular indictment was made public. It relates to 4 accused. It is directed against Nebojsa Pavkovic, against you, Vladimir Lazarevic, against Vlastimir Djordjevic, and against Sreten Lukic. As has been made public by this tribunal, the accused Vladimir Lazarevic arrived here in The Hague last week, to be precise on the 3rd of February. And indeed he is the first out of the 4 gentlemen I mentioned just now to arrive here in The Hague to stand trial. There is some information I would like to give on the indictment itself. I'm not going to read the indictment, of course, but I think I owe it to the public in general, and also to those who are following these proceedings from their homeland, that according to this indictment, the accused, Colonel General Vladimir Lazarevic, as commander of the Pristina Corps of the Yugoslav Army, the VJ 3rd Army, is being accused with having planned, instigated, ordered, committed, or otherwise aided and abetted in the planning, preparation, or execution of the alleged crimes of 4 counts of crimes against humanity contained in Article 5, deportation, that is, other inhumane acts, particularly forcible transfer, murder, persecution on political, racial and religious grounds, and finally 1 count of violations of the laws or customs of war, which is contemplated under Article 3 of our statute, which deals with murder inter alia. Mr. Lazarevic, apart from being charged on the basis of your individual criminal responsibility under Article 7.1 of the statute, you are also being charged on the basis of your superior or command responsibility as articulated in Article 7.3 of our statutes. This essentially means that you are being alleged by the prosecutor to be responsible for the crimes charged in the indictment if you knew, or rather because you knew, according to the indictment, or had reason to know that those crimes were about to be committed by your subordinates, or because you failed to take the necessary and reasonable measures to prevent them, or to punish your subordinates for having committed these crimes. I'll explain very briefly what is meant by committing for the purpose of the proceedings that have commenced against you, Mr. Lazarevic. Committing in this indictment refers to participation in a joint criminal enterprise as a co-perpetrator. The indictment alleges that the purpose of this joint criminal enterprise was, amongst others, the expulsion of a substantial portion of the Albanian population in Kosovo from the territory of the province of Kosovo in an effort to ensure continued Serbian control over that province. The prosecutor alleges that this joint criminal enterprise supposedly came into existence no later than October 1998 and continued throughout the time period when the crimes alleged in counts 1 to 5 occurred, beginning on or about the 1st of January of 1999 and continuing until the 20th of June of that year. The indictment alleges that each of the accused, and therefore you included, acting individually or in concert with others, with each others, and with others known and unknown, significantly contributed to the joint criminal enterprise using de jure and de facto powers which you had at your disposal. The indictment alleges, amongst other things, that in addition to the deliberate destruction of property owned by Kosovo Albanian civilians, forces of the FRY and Serbia committed widespread or systematic acts of brutality and violence against Kosovo Albanian civilians in order to perpetuate the climate of fear, create chaos, and a pervading fear for life. The prosecutor alleges in the indictment that the forces of the FRY and Serbia went from village to village and in the towns and cities from area to area, threatening and expelling the Kosovo Albanian population. Kosovo Albanians were frequently intimidated, assaulted, or killed in public view to enforce the departure of their families and neighbors. The prosecutor continues that many Kosovo Albanians who were not directly forcibly expelled from their communities fled as a result of the climate of terror created by the widespread or systematic beatings, harassment, sexual assaults, unlawful arrests, killings, shelling and looting carried out across the province. According to the indictment, forces of the FRY and of Serbia persistently subjected Kosovo Albanians to insults, racial slurs, degrading acts, and other forms of physical and psychological mistreatment based on their racial, religious, and political identification. All sectors of Kosovo Albanian society were displaced, including women, children, the elderly, and the infirm. This is what the prosecution alleges in the indictment against you. The indictment alleges also that the forces of the FRY and Serbia, acting at the direction, with the encouragement, and with the support of yourself, Vladimir Lazarevic, murdered hundreds of Kosovo Albanian civilians as part of a widespread and systematic campaign of brutality and violence that resulted in the forced deportation of approximately 800,000 Kosovo Albanian civilians. In general, the prosecutor alleges that you, Colonel General Vladimir Lazarevic, was appointed commander of the Pristina Corps of the VJ 3rd Army in December of 1998, and that you assumed command no later than the 6th of January of the following year, that is of 1999. According to the prosecutor, you exercised your authority as commander of the Pristina Corps, as well as through the FRY law on defense, and through joint command and coordination structures and mechanisms, military-territorial units, civilian defense units, and other armed groups in relation to events in Kosovo from January 1999 to June 1999 inclusive. The prosecutor further alleges that your subordinates included members of the MUP, military-territorial units, civil defense units, and other armed groups. This is the background for the charges that have been brought against you. The president of this tribunal, President Meron, on the 2nd of February 2005, assigned this case, your case, to Trial Chamber 2, of which I am the presiding judge. I myself, as presiding judge of Trial Chamber 2, 2 days later, on the 4th of February, appointed myself as the pre-trial judge for the purpose of this, for the purpose of today's initial appearance. Having said so, I will now proceed with your initial appearance. And this I am doing pursuant to Rule 62 of the Tribunal's Rules of Procedure and Evidence. Then I will move to the most important formality of this appearance, that is to formally charge you. Before I proceed, however, as I will be asking you some questions, it is my duty as presiding judge to inform you that you do have a right to remain silent should you choose to do so. In such an event, we have provisions in our rules and regulations that indicate to the pre-trial judge the way to follow. First of all, it is my duty as pre-trial judge in charge of this initial appearance to ensure that you are adequately represented. I have not only seen and heard Mr. Bakrac, but I have also reviewed the decision of the registrar dated 4th February 2005, which indicates that two things, or three things basically. First, that you have informed the registrar that you will be seeking to benefit from the legal aid that is put in place by this tribunal. We will not be dealing with that in this initial appearance, but in the status conferences that will follow suit. Secondly, that you have indicated the name of Mr. Bakrac as your counsel of choice, and that pending the procedures that relate to your request for legal aid, the registrar has been more than happy to appoint Mr. Bakrac, who has already got extensive experience before this tribunal. He was one of the lawyers in the Kronielac case. Have appointed him for a period of 120 days, effective from the date of this order, and then, of course, the situation will crystallize once the dynamics of your future application for legal aid would have been processed. I do want to have a feedback, however, from you, because it's my responsibility to do this, that you are happy with the arrangements that have been made by way of representation by the registrar for the purpose of today's initial appearance.
Mr. President, I am satisfied with the organization of today's proceedings.
Okay, I thank you. Later on, Mr. Lazarevic, I will be asking you whether you are prepared to enter a plea to the 5 counts that are brought against you in this indictment. But before I reach that stage, there are a few questions that I would like to ask you. Could you please stand up? Could you please give me, as pre-trial judge, for the record, your full name and surname?
Vladimir Lazarevic.
Vladimir Lazarevic.
What is your rank?
General Pukovnik.
Colonel General.
By any chance, do you have any nicknames that others refer to you with, or that you know are used when referring to you?
Interpreters could not hear the answer.
He said no, not that he knows of. Could you give us the date and place of your birth, please? Let's start with your birthday.
The 23rd of March, 1949.
And where were you born?
In the village of Grnčar, the municipality of Babušnica in Serbia.
All right. In anticipation of another further question that I will be putting to you, could you tell us, please, what is your nationality?
Srbin.
I'm a Serb.
In other words, you are a citizen of the
Serbia and Crne Gore.
Serbia and Montenegro.
Yes.
Excuse me, Your Honor. In connection with his place of birth, I should indicate to the court, it appears we have a typographical error in the spelling of his town. In the indictment, it appears as Gricar, G-R-I-C-A-R. I would like, at this time, Your Honor, to make an oral motion to amend the indictment to correct that spelling in paragraph 2 of the indictment to G-R-N-C-A-R.
I suppose we better first check how it is spelled correctly. Here it says in the indictment that he was born in the town of Gricar on the 23rd of March of 1949. How do you spell, yes, Mr. Bakrac?
Your Honor, May I be of assistance? In the Serbian version, in the BCS version, there is no misspelling. The spelling is correct. That is to say, Grnčar, G-R-N-C-A-R.
It's the English translation.
That appears to be correct, Your Honor.
Is there any objection on your part, Mr. Bakrac, that wherever Grnčar appears misspelled in the English version of the indictment, that be corrected to reflect the correct spelling?
Naravno da se ne protivim, časni sude.
Of course I'm not opposed to that, Your Honor.
So, I don't know how many times it occurs, whether it occurs only in that, in paragraph 2 of the indictment. I'm not in a position to help you more than that. But if that is so, by order of the pretrial judge, the word or the name Grnčar, as it appears in line 2 of paragraph 2 of the indictment, and should it appear elsewhere in the same indictment, that it be substituted by the name G-R, you tell me, I mean, I don't know how to spell it.
I believe it's G-R-N, cha, the C with the full banana, A-R.
A-R. A-R, Grnčar. All right, that has solved the problem. Now I'm going to ask you what is the address at which you resided last before you were taken into custody and transferred to The Hague. Since this is very much a personal matter, if you prefer to give me the address in private session so that no one else outside this courtroom will will know what is your home address, then I can willingly accept to go into private session. Yes, Mr. Bakrac.
Časni sude.
Your Honor, with all due respect, by your leave, I just need to make a correction. General Lazarević was not arrested. He voluntarily surrendered. Well, that is the interpretation I received. I didn't look at the transcript.
I never said that he was arrested. I said he was taken into custody. Because when he surrendered himself, obviously he is then taken into custody and brought over. But I never mentioned or made use of the word arrested. I was very careful there. So would you like to give me your address in open session, or would you like to say it in a private session?
Mr. President, I am prepared to give my address right now. The street is Pavla Jurišića Šturma, number 46, Niš.
Okay, I thank you. I want to make sure that your family has been informed of your transfer to The Hague, and that you are being detained here in the United Nations Detention Unit in Scheveningen.
Yes, Mr. President.
And I also want to make sure that the personnel at your embassy, the embassy of Serbia and Montenegro, are also informed of your transfer to The Hague and your detention in The Hague.
Yes, the embassy has also been informed.
Would you like me, as presiding judge in these proceedings, to contact anyone on your behalf to inform him or her or them that you are now here in The Hague and that you're being detained in the detention unit?
I think that for the time being there is no such need, Mr. President.
Thank you. Now, you stand accused here, but as an accused, you have a right to not only a fair trial, but when that arrives, but you also have a number of other related rights. These are dealt with both under our statute and also sometimes in a repeated fashion in our rules. I am now going to ask the Deputy Registrar to read out to you in the entirety Articles 20 and 21 of our statute, so that you will be made, I will make sure that you are made aware of the existence of these rights, and having heard or followed the reading of these two articles, should you have any questions, please do not hesitate to put them to me, either directly or through Mr. Bakrać. Registrar, could you read out Article 20, please?
Article 20. Commencement and conduct of trial proceedings. Trial chambers shall ensure that a trial is fair and expeditious, that proceedings are conducted in accordance with the rules of procedure and evidence, with full respect for the rights of the accused and due regard for the protections of victims and witnesses. A person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him, and transferred to the International Tribunal. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instruct the accused to enter a plea. The trial chamber shall then set the date for trial. The hearings shall be public unless the trial chamber decides to close the proceedings in accordance with the rules of procedure and evidence.
Yes, Registrar, could you please read out Article 21 now, please?
Article 21. Rights of the accused. All persons shall be equal before the International Tribunal. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. The accused shall be presumed innocent until proved guilty according to the provisions of the present statute. In the determination of any charge against the accused pursuant to the present statute, the accused shall be entitled to the following minimum guarantees, in full equality. A. To be informed promptly and in detail, in a language which he understands, of the nature and cause of the charges against him. B. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence and to defend himself in person or through legal assistance of his own choosing. To be informed if he does not have legal assistance of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. E. To examine or have examined the witness against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal. G. Not to be compelled to testify against himself or to confess guilt.
Okay, I thank you, Registrar. Colonel Lazarevic, have you understood the the extent and the meaning of these rights. I need to move to something which is fundamental now. Have you received the indictment in your own language? Have you been served?
Pardon me, Your Honor. His response to your last question about whether he understood those rights did not appear in the transcript.
Yes, I heard him say yes. I will repeat the question, and please speak into the microphone, because sometimes the interpreters cannot catch up unless they can hear properly. I asked you whether you, after having listened and heard the reading out of Articles 20 and 21 of the statute, whether you have understood the extent and also the importance of these rights.
I have understood both Article 21 and Article 20 of the statute, Mr. President, the extent of the rights, that is.
Thank you. And now I would like to know, or have a confirmation actually from you, that you have been served with the indictment that I referred to earlier in your own language.
Yes, I have received the indictment in my own language.
So I do take it that you are fully aware of its contents, and therefore also of what you are being charged with.
I am aware of the contents of the indictment.
Now, there are two ways in which we can proceed. One way is to, for me, or of course the registrar, to read out the entire indictment, which is here. Or else, if you so wish, you can waive this right to have the indictment read out in public, in which case I will proceed with whatever information I think is necessary for the time being. Does the accused want the indictment to be read out in its entirety, or is he waiving that right? Have you consulted with him, Mr. Bakrac?
Yes, Your Honor. I shall take it upon myself to answer this, because this is a professional question to a large degree. I have talked to the General. There is no need to read out the indictment in detail. We are quite satisfied just to go through the counts and to have the accused enter his plea.
Right. The procedure I will follow, therefore, is as follows. First of all, I would like confirmation from you in any case that you agree that there is no need for me to read out the indictment in its entirety.
I agree with everything that Mr. Bakrac said, Mr. President.
Thank you. I wish all my clients were like you when I was still exercising in private practice. I must advise you, although this is strictly speaking a legal matter more than anything else, that in terms of, or pursuant to our Rule 62A 3, you have a right to enter a plea of guilty or not guilty on each count today, during this initial appearance. Or, should you so desire, within 30 days from today. Our rules do not impose on you the responsibility of pleading guilty or not guilty today. You have this other option. I don't know whether you have had the opportunity to discuss this with your counsel, but I would like to have some indication as to whether you are prepared to plead, to enter a plea today, or whether you are going to postpone it till later, that is within the 30-day from this initial appearance. I also must guide you to the effect that should you decide not to enter a plea at all, not just now but even later, then obviously that event is dealt with, will be dealt with in accordance with our rules, which would require of me to enter a plea of not guilty on your behalf. Yes, is there an intention to enter a plea today, or are you going to ask for a postponement?
Mr. President, I agree, and I am prepared to enter my plea today in view of the indictment.
I thank you, Colonel Lazarevic. In view of the fact that you waived your right to have the whole indictment read out in public, I will just read out to you the 5 charges contained in the said indictment of the 2nd October 2003, and then the procedure will be as follows. After reading out each of these counts, I will ask you, how do you plead to this particular count, guilty or not guilty, and then please enter your plea. Your answer in each case should only be guilty or not guilty. If you do not answer at all, then obviously we will have to see whether you are postponing your answer or whether you're just deciding to remain silent. You should bear in mind that for all the counts, you are charged both under 7.1, that is individual criminal responsibility, and under Article 7.3 of the statute, that is command responsibility. That's why I explained these earlier on in my introduction. The first count against you, Colonel Lazarevic, is a charge of deportation, a crime against humanity, punishable under Article 5D of the statute. How do you plead to this charge, first count? Do you plead guilty or not guilty?
Mr. President, I'm not guilty.
For the record, the accused has entered a plea of not guilty of the first count. In the second count, you are charged with other inhumane acts, being forcible transfer, a crime against humanity, punishable under Article 5I of the statute. How do you plead to this charge? Guilty or not guilty?
Mr. President, I am not guilty.
For the record, the accused has entered a plea of not guilty to the second count. The third count, you are charged with murder, a crime against humanity, punishable under Article 5A of the statute. How do you wish to plead to this third count of murder? Guilty or not guilty?
Mr. President, I am not guilty.
For the record, the accused has entered a plea of not guilty to the third count. In the fourth count, Colonel Lazarevic, you are charged with murder, this time as a violation of the laws or customs of war, which is punishable under Article 3 of the statute of this tribunal and recognized by Article 3.1a, murder, of the Geneva Conventions of 1949. How do you wish to plead to this fourth count of murder? Guilty or not guilty?
Mr. President, I am not guilty.
Thank you. And for the record, the accused has entered a plea of not guilty to the fourth count. And the fifth and last count is one of persecutions based on political, racial, and religious grounds, which is punishable under Article 5H of the statute of this tribunal. How do you wish to plead to this fifth count? Guilty or not guilty?
Mr. President, as for count 5 as well, I plead not guilty.
I thank you. You may sit down. For the record, the accused has entered a plea of not guilty to all 5 counts of the indictment, and this, of course, is referred to the trial chamber so that it may act in accordance with Rule 62 bis and instruct the registrar to set a date for proceedings pursuant to the same Rule 62 bis. Now there are a few final matters that I need to address. The first one is that once there has been this initial appearance today, the pre-trial judge or the pre-trial chamber is bound by Rule 65 bis A to summon and hold a status conference within 120 days from today. That status conference will then be followed by other status conferences, each one of which has to be summoned, convened, and held within 120 days counting from the previous status conference. So the first status conference will be convened within this time period. I cannot assure you or tell you who, whether it will be myself who will preside over that status conference, or whether it will be some other judge from my trial chamber. That I will need to discuss with the other 2 permanent judges of trial chamber 2. Although it is my prerogative to decide who will be pre-trial judge. For the time being, I only need to give you some information of the purpose of these status conferences. You will, of course, be informed of the date in good time, and your lawyer will be informed too. The purpose of a status conference is twofold. First, it is to organize and facilitate the preparation of the trial, and secondly, it gives the pre-trial judge and the accused and you the opportunity to meet face to face and make sure that you are being treated well, that all your rights are being respected, and that if you have any reason to complain on anything or against anyone, that you will be given the opportunity to do it here in public or in private session. I will give instructions to the registrar to start the ball rolling so that we can look forward to fixing a day for your trial without any undue delay. For the time being, you are going to remain in custody, but it is also my responsibility, I'm sure your lawyer would have advised you on this already, but it is my responsibility also to inform you that our rules, Rule 65 in particular, do contemplate the possibility of being released conditionally, going out on bail pending the start of the trial. I cannot give you advice on this, but I'm sure Mr. Bakrac will, and this is a matter that you will discuss with him. I turn left, and I think I will just say it for the sake of formality, but it is my responsibility as well to remind you that pursuant to Rule 66 of our Rules of Procedure and Evidence, you have 30 days to disclose to the defense in a language which the accused understands all the supporting material which formed the basis or accompanied the indictment when confirmation was sought by Madame Del Ponte. Turning right again to you, Mr. Bakrac. Again, I am addressing you because this is a legal matter more than something that the accused can handle himself. You are, of course, reminded that pursuant to Rule 72A of the Rules of Procedure and Evidence, you have a 30-day period for the filing of any preliminary motion. Once you have received all the supporting material in accordance with Rule 66 that I have just mentioned to Mr. Hannes. I don't think there is anything else that I need to point out, except that I will turn to the lead counsel for the prosecution in this case and ask whether there is any other matter that you would like to raise.
Your Honor, I just want to bring it to the court's attention that the charges in this indictment are identical to the charges in case number IT 99-37 against 3 accused currently in the detention unit, Mr. Milutinovic, Mr. Šainović, and Mr. Ojdanić. It's our present intention to file a motion to join this matter with that one, and I just bring that to your attention. That matter is before Trial Chamber 1, so it's something that I believe the court should be aware of.
Yes, I thank you for that information, which I'm sure Mr. Bakrac has taken note of. Of course, we will deal with that matter even when it arises, because it does, according to me, present some problems in any case. The defense, Mr. Bakrac, is there any matter that you would like to raise before we rise?
No, Your Honor. I have nothing to add, nothing to raise. I wasn't aware of that intention on the part of the prosecution, but the defense will have ample time to present its views and positions. No further matters. Thank you very much, Mr. President.
Last thing, I address the accused directly. I want to make sure, first and foremost, that since you decided to turn in, from the moment you decided to turn yourself in, till the moment you walked into this courtroom, that you have been treated well by each and every person you came across.
Mr. President, everybody has treated me very properly. I have no matters to raise in that regard.
Thank you. You will, as I explained, already be detained in the detention unit. I can assure you that the detention unit is very professionally run by a most capable commander, and that the conditions that are in place there are, to my knowledge, at least exemplary. Should there be any reason for you to complain, I am, and my trial chamber is at your complete disposal. Should there be any personal matters that are not properly or adequately attended to, and that includes even health matters, or should you have reason to complain at the way you are being treated, then please do not hesitate to approach the trial chamber. Mr. Bakrach will explain to you the way to go about it. I can assure you that we are not here only to do justice, to administer justice to all the parties involved, but also to make sure that all your rights as an accused are protected and are respected. Did I make myself clear?
Mr. President, I have no requests, no comments, and I thank you for asking.
Okay. That brings this initial appearance to an end. You will be escorted back to the detention unit, and we will have the first status conference, as I said, within the 120-day time limit we have in the rules. I thank you, and good afternoon to everyone.
All rise. Pěkně